All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. Whoa. This is the time and date set for oral argument in cause number CV220741. Augee versus Wright. These proceedings are being video and audio recorded as well as live streamed, so we ask you to please identify yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to argue. Appellant's counsel is responsible for watching the clock to reserve any portion of that time for rebuttal should you require. Also, we've read the briefs, we've discussed this case in conference, we're familiar with the facts of this case, so at this point, counsel, you may proceed.
Thank you, Your Honors. Good morning. So this case, and I apologize, I just skipped over. My name is Ross Meyer. I represent the appellants, Mr. Augee, in this matter. I apologize for skipping over exactly what you said. So this case has come before the court before when there was not an evidentiary hearing on the matter of whether there was a settlement in effect after a settlement conference that bound the foundation in this case. And the foundation was an entity that provided nonprofit services and had materials and equipment in the family home in the divorce. And so part of that settlement was how does the husband and the foundation get those materials back as part of the settlement. That was a main issue. The Mrs. Wright, or Miss Wright, wanted a release from the foundation as part of the condition of the settlement. And what happened here is on the record at the settlement conference before Judge Hilliard, Mr. Augee stated that he was not a board member for this issue of the settlement and the release. What's transpired now that it's come back down is there was an evidentiary hearing. Mr. Augee testified. There was a number of exhibits admitted, and then the lower court ruled that there was apparent authority or implied authority as the foundation as the principal and Mr. Augee as the agent that Miss Wright could have reasonably relied on.
So, counsel, if you could for us, who bears the burden of proving apparent or actual authority in this matter?
Miss Wright bears the burden because she's seeking to enforce the settlement.
And in your understanding of what took place below, can you point to us in the record what information was presented during that evidentiary hearing that furthered her point?
Right.
Let's play devil's advocate.
Yeah, so if I'm playing devil's advocate, their argument relies on Exhibit 16 is what it's called. It was a letter from the foundation to Mrs. Wright 2 months after the settlement.
One saying we no longer agree.
Saying we no longer agree. Correct. And that's what the lower court relied on, and that's what appellees rely on, saying, well, look, if they're revoking it now, there had to be some authority before.
So if we pause for a moment and look at we no longer agree, even if they had agreed in the past,
even if the foundation had agreed?
Had agreed.
Okay.
What are their obligations under settlement agreement to which they're not a party?
Well, so two parts, and it's a little bit of a gray area, but their obligation would be if they were made aware that Mr. Augee stated something that was inconsistent with their position, to then notify the other party and indicate that, look, this is incorrect, and correct that, because at some point, and with continued actions, that could bind them, not from that moment, not from that moment forward, but some continued action could bind them in the future. The second, and so that's really where I'm coming down on this, is that there's no action that is prior to the settlement conference or during the settlement conference that the foundation, this just keeps getting in my away, I apologize. I'm talking with my hands. That the foundation took that Ms. Wright could actually say she relied on. There's no action by the principal that manifest that reasonable
But
belief.
before the separation, was there any question that whether Mr. Augee had authority to bind the foundation?
I apologize, the separation,
Before there was any kind of dispute between the parties, and before he left and left the property there at the residence, had there been a long history of Mr. Augee simply acting on behalf of the foundation?
It's not in the record specifically, at least not from the transcript and the evidence there. But Mr. Augee had been part of the foundation. He had been part of the board. He did testify that he formed the foundation. Well, you can't own a nonprofit. He was part of the team that ran the nonprofit. On the record, though, however, it was stated that he was a non-voting member on this matter on the board. And he stated that he would need to get the release from the board, while he indicated, yes, I believe they'll agree to this, or they will agree to this. The statements of the agent are not sufficient to create apparent authority. And
Did he actually, at any point during this evidentiary hearing, during the settlement negotiations, indicate, I have the authority to bind the foundation to this agreement?
that's not in the record. And the other aspect that is in the record is that he stated, on the second go-around at the Superior Court, he stated that during the settlement conference, he didn't speak with the board representative that was there at all.
Wouldn't the fact that the board representative was there indicate that maybe he wasn't the guy?
That is exactly our position, is that why would there need to be a board representative there if he is the agent?
And is there anywhere in the record where the board representative that was there was questioned about their authority?
No.
Okay.
Were there any depositions, or my understanding is no one from the foundation testified at the hearing, is that?
That's correct.
Correct. And no depositions asking them, or no introduction of testimony from anyone?
No, Your Honor. And to clarify, Mr. Augee, at the time of the second hearing that we're appealing now, is a member of the foundation. And he's the sole member, but at the time he was not. And so just to clarify.
This isn't necessarily dispositive of anything. But let's say he had represented, I have authority to speak on behalf of the foundation. Would we bind if the foundation came in after the fact, doesn't know that he's speaking on their behalf, would the settlement agreement bind the foundation?
I don't think so. There could be a couple changes to your hypothetical that could make that, but on that hypothetical, I don't think so, simply because Ms. Wright can't rely on the agent's statements to bind the principal. But if that were done in open court, and the board member representative were in court and didn't say something, I could see an argument being made that the board member stayed silent.
What if there had just been a long history of him, Mr. Augee, acting on behalf and leading his wife to believe that he had authority? I realize this isn't.
Yeah, no, well, it's an interesting question, because presume during the marriage he was acting on behalf of the foundation, and Ms. Wright knew that, and so I can see that question coming up. I think it's two parts. One, the actual authority was revoked by that October email, so I think that's one clear line. And then the second would be that on the record there were statements that the foundation had to sign the release, had to take some other action before the settlement would be effective, and that was a condition precedent of the settlement agreement. And so I think in some case, some hypothetical, that may make sense based on a long course of history when the person did actually have authority, but here, because it's been revoked, I don't think it.
I want to talk about that email that revoked his authority, because we have an email that revokes his authority, and again, playing devil's advocate, you then have a situation where he goes into the settlement agreement and says, this is what the board's going to agree to, is my understanding. So under the law, it's an implied sort of standard that we're looking at, that Mrs. Wright is alleging. And so my question is, are we in a situation where, although that email was in existence, that when they went into that settlement conference and the statements from Mr. Augee and the fact that the board member was there in another room created an implied agency that he had the authority to bind the board?
So you're saying the fact that the board member was there, did that create an implied agency?
And sort of a revocation of the email that took away his authority by sending him in there, and the board member, being in another room, having discussions about what they would agree to. He went into the settlement conference, although alone, he knew what they were willing to agree to, and, asserted that position. So, counsel for appellee is arguing that, that was an implied representation. So how do you get around that?
Yeah, so even if you assume that, let's assume that the board member was there, and it's not in the record, but let's assume that for that settlement conference, Mr. Augee did have the authority of the board, and Ms. Wright didn't know it, but based on the board member there, she believed it, okay? Even if you assume that's completely true, there's nothing in the record that states or shows that Ms. Wright reasonably believed that. She didn't testify in this. There's no evidence admitted as to what she believed. And that's where you have to get based on the action of the principal. And so there's no evidence here to base the Superior Court's ruling that Ms. Wright reasonably believed that because the board member was there, Mr. Augee had apparent authority. And that's how you get around that. And I don't think the Superior Court's ruling can stand without that evidence, because otherwise we're just guessing and have hypotheticals.
Thank you.
I'll reserve the rest of my time unless there's other questions.
Good morning. I'm pleased to court. I'm Gary Rosser. I represent the appellee, Patricia Wright. I'm going to, because this is a question of fact, as the court in the first appeal clearly stated, I'm going to focus on those facts, and that's what the court seems to have focused on. It's questioning of appellant's counsel.
Let's start at the beginning. Your client bore the burden of proving apparent authority. Do you agree?
I agree.
Okay. And so I was on the first panel that heard this case.
I know you
so
were.
And I didn't remember, it was a Gary, not whatever I pronounced, so Augee. I'm sorry about that. Augee, not a Gary. Mm-hmm. What we have is an evidentiary hearing where it doesn't appear that there was a whole lot presented on the issue at hand. What I have is the court saying during the evidentiary hearing, petitioner testified that he currently has the authority to bind the foundation, but that doesn't harken back to when they were engaged in settlement negotiations. So at the settlement negotiations hearing, the court basically said, you have to get this release. Yes, I have to get this release. And we went through that kind of in detail the first go around here. What has changed between the first go around and now is you've had this evidentiary hearing, but I don't see anything in the evidentiary hearing that is, aha, that's the fact question that needed to be answered. Now I understand. So can you walk me through that?
Sure, and I'm going to go back to the original transcript from the settlement conference, the memorialization of the Rule 69 agreement. During that...
we said that wasn't enough. So could you point to something during the hearing on remand that shows?
I am. I'm going to start there, if you don't mind, if I'm going to start there and then get and lead to that. So at the settlement conference, on the record, under oath, Mr. Augee said that that he had the opportunity to consult with Ms. Hatch, who was a representative of the board. And then we have our evidentiary hearing, and this really boils down to one passage in the testimony, and the judge actually did my job for me to some extent. If you look at the record of the trial transcript starting on page 117, the first line, the court starts to inquire about what Mr. Augee's authority is, and the court asked the question, okay, but Mr. Augee, I know you also said in the ADR, because the transcript says you said it, that you talked to the foundation, a representative of the foundation prior to the ADR, and told them about the options, implying that one of the options would be a release in favor of Ms. Augee. That's how I read it. And then this is the important part. He responds, I did discuss with her, Judith Hatch, in advance. There was a brief discussion. There weren't a lot of options. The instructions were, we want our stuff back and do what you have to get our stuff back. The court says, including a release. Mr. Augee says, well, yeah, she said, get our stuff back and we'll sign a release. This was prior to...
Yeah, but that's get our stuff back. And has the stuff ever gone back?
The stuff has not gotten back because the delivery of the items was conditioned upon the signature on the release, which has, even though demanded, has never happened.
But I want to go back a minute because you're talking about this conversation between Mr. Augee and the board member. Was Ms. Wright aware of that conversation at all?
No, but she was aware that Ms. Hatch was at the settlement conference, and she was aware that they were allowed to confer. Now, at the evidentiary hearing, Mr. Augee testified that they were not able to have any contact or any discussion. However, on the very day that it happened, he stated, again on the record under oath, that he had an opportunity to discuss it with Ms. Hatch. And
but again, I want to go back to the law talks about a reasonable belief or an implied agency here. What did Ms. Wright believe? What is in evidence that Ms. Wright believed on that day bound the board?
The fact that Ms. Hatch was there and that Mr. Augee stated that they would agree to it. They had a board meeting that night. At the evidentiary hearing, he testified that there was a board meeting, that he did relay the terms.
But I want to go back to the settlement conference, because at that time is when she had to believe that he had the authority to bind the board.
Right,
and so the question is when you look at that transcript, what you see is a judge that's overseeing the settlement conference, and the judge says, don't you have, and I'm paraphrasing here, but don't you have to go back and will the board agree to this term? And so the judge really clearly understood that Mr. Augee did not have authority to bind the board at that time. And I assume there was counsel representing Ms. Wright at that same settlement conference that heard all of that as well. Is that true?
That was me that was there, yes. And what he said was that they would agree to it. They had a board hearing that night.
But don't you have to have something more than something from the agent? If you're seeking to impose liability on the principal, in your view, would you have a lawsuit now against the foundation if they didn't do something that Mr. Augee agreed to during a proceeding to which the principal was not a party? Could you go and require them to do something based on a representation from Mr. Augee? without having them be a party at all?
I'm sorry, could you restate your question?
I'm just trying to figure out, the general, do you agree with the general principle that you can't rely solely on what an agent says to establish that the agent has authority to act on behalf of the principal?
I do not agree with that statement.
All right, let's go at it a little bit differently. So, at any point, was the board asked to sign off on this agreement?
On the agreement?
Right.
No.
They had obligations.
Well, let me rephrase that.
They had obligations under the agreement, correct?
They did.
But we're arguing about whether or not Mr. Augee had the authority to enter into that. So you have a board member there, you have this agreement where you're trying to impose obligations on a third party and waivers of their rights. Agreed?
Correct.
But they're not going to sign off on this agreement? Typically, this happens in a contract situation. You're trying to bind a third party to a contract between two individuals. The third party is unrelated to this agreement. So you definitely have to have some authority to say, Mr. Augee, I'm both husband in this proceeding and I'm board member with authority to act on behalf of the board, and I'm going to sign this on behalf of both of us. That would make sense, and then we'd know he had authority. Agreed?
Yes.
Less than that, we've left a condition that must be met, which is the signing of the release that imposes their obligations to begin. Agreed?
Yes.
That never happened.
I disagreed.
The release was signed?
No, I'm sorry, the release was not signed, but they agreed to the terms. Well, let me rephrase that. Ms. Augee could reasonably believe that he had authority.
But the reasonable belief was based on silence, on no one has spoken other than the agent. And you may disagree, but I think there are cases that suggest that you have to have something from the principal to bind the principal. You can't just rely on something an agent says. And you're saying, well, it was there because the principal was in another room. But you have silence. And now you've had an evidentiary hearing, a chance to develop the record. No one is called from the foundation. So we're left with what you have is silence, and you're saying an agent can bind the principal. That's the struggle we're having with your argument.
Going back to your question to appellant's counsel, a couple of questions. One, yes, the Mr. Augee had acted on behalf of the unilaterally on behalf of the foundation throughout the course of the marriage. Number two,
but did Ms. Wright testify? Why
no,
did
she didn't testify. She did not testify to that.
So that's not in the record.
So
That's
not in
being
the record,
considered.
no.
But how do we know what her basis for relying on that the principal had given Mr. Augee authority to act on behalf of the foundation? What's your best evidence seems to be silence and then a letter or email after the fact saying we're revoking. Is there anything other than those two things?
The fact that he testified during the hearing that prior to the settlement conference, he had discussed with Ms. Hatch, who could not testify because she was deceased at the time of the evidentiary hearing, that they just wanted their stuff back and they would agree to assign a release for that. The fact that happened, that she was there, and that more than 2 months passed.
Didn't she tell us she would sign it after the property was released?
No, the signature was to come before the release of the property.
Okay, if we were to even, all of that is true. What difference would it have made that they had a board meeting that evening to ratify whatever had happened at that settlement conference? Why would they need a board meeting later? That's what if he had the authority to bind them, he could have signed on behalf of himself, he could have signed on behalf of the foundation, we'd be done and we wouldn't be here. But here we are on second go around. Okay, so he couldn't sign on behalf of the board, do we agree?
he was a non-voting member, so he could not agree. I believe he could probably have signed had they given him the authority at the settlement, at the board meeting later. But the better practice would have been for one of the other board members to have signed it.
Okay. Any board member could have signed off on the obligations imposed upon the board, the foundation, but none did. We have to wait until later and there's a board meeting. So nobody said, I have the authority to bind this board to this agreement at this specific point in time. There was always something that had to go on after. Would you agree? And there is no writing that says, I will release Ms. Wright from any and all liability if she releases our property, because that was supposed to take place later as well in the release. They'll sign the release, she'll give them back the stuff.
There is no writing that says that. I would agree with that statement, yes.
So we're left with the fact that your client was left with the burden to prove that Mr. Augee was authorized to enter into this agreement, when really there isn't an agreement between the foundation and Ms. Wright, because the things that were supposed to happen never did. Am I wrong?
I believe you are, and again, I would point to his testimony at the evidentiary hearing that prior to the settlement conference, he had been told that they would sign a release.
He was told that they would sign a release. He was told what they would do. But they didn't say, you go sign the release for this board, did they?
They didn't say that, no.
He was authorized. In fact, his authorization was revoked, was it not?
He was authorized to agree to the release, and then they later tried to withdraw that authorization in the letter, Exhibit 16 in the letter of February 2019.
I think what he said specifically, if I'm recalling the record directly, is that this is what they said they were willing to do. They, not I, this is not what I am willing to do, this is not what I am willing to do on behalf, this is what they said they were willing to do. But they didn't have anything in writing that was an offer. They have his statement, and all of it was contingent on other things happening. He never said, I'm authorized to make this agreement and I'm entering into it. What I'm having in trouble with is, why are we not in the exact same position we were before the evidentiary hearing? Because nobody from the board testified. Mr. Augee didn't say anything other than what he said basically during the settlement conference. So help me find something to hang my hat on your client meeting or burden in this instance, following the evidentiary hearing. What is that nugget that I am not seeing at this point?
I would point you back to his testimony regarding the discussion that he had with the board.
And that was before.
No, but it's testimony at the hearing. You're talking about the hearing on remand.
Right, but that testimony related back to prior to the settlement conference.
But I go back to Judge Campbell's question, is it's your client's burden to prove. So you're tying his testimony and say that his testimony is proving your client's case, when she's the one that has to have the understanding, the reasonable understanding that he was the agent, or believe that it was implied that he was the agent. Yet she didn't testify at all to say that she believed that he was acting on behalf. We have nothing in evidence to show that she had any belief that that's what was actually happening. We only have testimony from Mr. Augee saying this is what happened.
And I had no authority.
I had no authority.
That he was not acting as the agent of, I need to take it back to the board, I need to do these steps. They said they, not we, will agree. They said they will agree. We'll talk about it at the board meeting tonight.
He said that at the settlement conference, when we were memorializing the settlement agreement, he said that he was acting at their direction And that's in the transcript, which I can find quickly.
I'll go back and look at the transcript. Don't waste your time looking for it.
Sure.
Just one more question. Let's say the foundation files a lawsuit right now against Ms. Wright and says, you have our property. Seems to me under your theory, you're suggesting that they've already agreed to waive any liability for any property. Are you saying she could just respond to a lawsuit that the foundation files saying, you have our property? She could now just say, no, you agreed to a waiver of any liability for that property.
Well, that wouldn't be our strongest defense because the statute of limitations is already run on that, so that would be where we would come out of the gate. But yes, that defense would be raised as well because they had agreed. She
has no liability. She has under your theory, it doesn't seem like she even has to return the property. The foundation has said you have no liability for anything. So she can keep the property, owes them nothing? Is that?
Well, assuming that the statute of limitations had not passed,
Okay.
then that is the defense that we would raise, and we would argue that. And that comes
And even though
to,
they hadn't been a party to the litigation at all, you would, okay.
I'm sorry, and that comes to one of the points that I wanted to make that has caused us so much problem over the last 5.5 years that this case has been pending, which is the fact that the original decision of the court vacated the decree. And what we would ask is that if the court finds that Mr. Augee did not have authority to bind the board, a third party, that simply be stricken from the settlement, and that the decree and that the decree stand as between the two parties, because there's no question that he had the authority to bind himself, and that she had the authority to bind herself, and that they reached an agreement as to the property as between the two of them. Because originally the court had vacated the decree, and what we would ask is that if the court finds that he did not have authority, that you simply vacate that portion of the decree.
But that's under the assumption that there's a statute of limitations and nothing can happen. If that was part of the parties' agreement, was somebody's going to have responsibility for this property. There's a potential claim against our marital estate, and the parties were agreeing that this was how it was going to be taken care of. That wasn't an important part of the agreement?
I will tell you that from my client's perspective, no. I can't speak on behalf of Mr. Augee. I can tell you that the test, if you review the transcript again, that's where his focus was, and the court shut him down. That was not an issue for that hearing, whether or not they were entitled to the property back. It was simply whether or not he had authority to bind them to a release.
All right.
Thank you, counsel.
Thank you, Your Honor.
I have a few points to make. This quote that appellees rely on also goes on to state that, but if we don't get our stuff back, we're not going to sign a release. And I think there's a couple points here. One, that was prior to anything with the settlement agreement. Ms. Wright didn't see that. So that wouldn't go to apparent authority. Maybe it would go to express authority, but not really, because that had already been revoked, and it was revoked by the board, and this was just one board member, so it's not express authority. to enter into this agreement. So because,
Let me just stop you there.
okay,
I want to get to his last point before you run out of time.
okay.
Okay? So, the first time this came around, we vacated the decree and sent it back for an evidentiary hearing. Why didn't anybody ask the lower court to enter a decree or something that excised at least this portion?
I don't know. I know that Mr. Augee was asking that the prenuptial agreement be utilized for the distribution of assets.
So he wants a do-over at the trial level?
Based on the transcript, that's what it appeared
Okay.
he was seeking.
All right. So if we were to agree that he did not have authority, we would remand for this to the trial court with what relief?
I think the relief would be that there is no settlement agreement at,
Why would it invalidate the entire settlement agreement? Because it was premised on this condition.
because the first decision
Right.
indicated that it was a
Right.
condition precedent.
I just want to make sure I understand procedurally where we are so we don't make it more confusing. These people
Right.
need to be divorced and done.
Yes.
We all agree on that. Here, here, we all agree.
But I'm still a little bit puzzled. Why does this matter if neither party now cares about the property if the statute of limitations has run? If the only part of that was something that was to protect Ms. Wright, it seems like that condition was something that Ms. Wright wanted in there to protect her from liability for that property. So if we just say, yeah, that part is out, why does that implicate a do-over on everything else?
Because entering into the settlement agreement, one of the main contentions of Mr. Augee and the foundation was to get that stuff back, to get that property back. And now we know that property is not going to come back. But if that was known at the time, Mr. Augee would have kept all of his, presumably, I mean, this wasn't on the record, but presumably he would have kept all of his arguments and positions in the divorce proceeding prior to entering into a settlement. And so he would...
So there was some benefit to him. It's not only a liability to him. There's property that's going back that he will have control over or will have something to do with as a member of the foundation.
Absolutely correct, because the foundation saw it as, well, our property went to your house, and now it's gone, so you would be tied in on that too, absolutely.
So the settlement agreement was contingent upon this clause, which was negotiated during the settlement, and if this clause goes away, the entire settlement agreement goes away.
That's how I
And
see
so
it.
the relief requested, which is excise it and confirm the decree, would not be the correct way to handle this?
I think absolutely not, and the reason is that would be changing the agreement of the parties, because Ms. Wright was saying, well, I'll enter into the settlement agreement if I get a release from the board, and now here we are 5 years later, and now she's saying, well, because the statute of limitations have run, now I'll enter into the settlement agreement without the foundation's release. And that's completely different from what happened at the settlement agreement. And so to modify that after the fact, that wasn't part of it. If it were part of it, I don't think we would have ever been up here on appeal. We would have said, look, this case is settled. If there's still claims between the foundation and the parties, that's a separate matter. The foundation isn't a party here.
Okay, I just want to make sure that we're not causing more problems than solving them at this point. Okay.
Correct.
Please proceed.
I want to make two other points. Actually, really just one other point is that one of the witnesses that Ms. Wright listed was Mr. Jim Minderinghausen, I think I'm saying that correctly, who was a board member at the time of the settlement agreement. He was not present at the ADR, but he was a board member. That person was not called at the evidentiary hearing. There was no evidence presented of their testimony, declaration, letters, anything of that sort. And so I think here what we're looking at is maybe there's something else, maybe there's some other evidence or key point that could prove Ms. Wright's position, but it wasn't introduced at the evidentiary hearing. And so because of that, we'd argue that there's not apparent authority and there's not express authority for the foundation to be bound here. Thank you.
We thank you both for your arguments here today. We thank you for your briefs. We will take this matter under advisement and issue a written ruling in due course. At this point, we are at recess. We'll reset the courtroom for the next hearing. And could I get another pen? This one is not working.